You won't even be able to see me with this microphone. In case you don't know yet, I'm Maeva Marcus, the third general editor of the Oliver Wendell Holmes Devise History of the Supreme Court, and very happy to have had the good fortune to be in that position when Robert Post produced his manuscript on the Taft Court. A truly monumental achievement about which the panelists this afternoon will have more to say. But before we get to the panelists, I thought it might be helpful to give you a short account of the checkered progress of the Devise history, so you might understand how Professor Post came to undertake such a massive project. The story begins, of course, with the death of Justice Holmes in 1935. In an unusual gesture, he left most of his estate, $263,000, a not inconsiderable sum in 1935, to the United States for the benefit of the people. President Franklin Roosevelt, in a message to Congress recommending the appropriate use of the bequest, described the gift as coming from, quote, one who, in war and peace, devoted his life to his country's service. Clearly, he thereby sought, with a generous emphasis, to mark the full measure of his faith in those principles of freedom which the country was founded to preserve, end quote. And the president urged, in conclusion, that the Congress, quote, translate this gift into a form that may serve as a permanent impulse for the maintenance of the deepest tradition that Mr. Justice Holmes embodied, end quote. Responding, Congress established a Holmes Memorial Commission, among whose members were Justice Harlan Fiske Stone and Felix Frankfurter, and as secretary, Justice Holmes's former clerk, Alger Hiss. The Holmes Memorial Commission suggested that the money be used for a memorial garden to be built near the new Supreme Court building, and for publishing a memorial volume of Justice Holmes's writings. A joint resolution of Congress in 1940 gave approval to that proposal, but World War II intervened, and no action was taken except to put the Holmes bequest into a non-interest-bearing account in the Treasury. Nothing further occurred until 1955, when Congress finally passed a statute that governs the Oliver Wendell Holmes Devise to this day. The act appropriated money to make up for the interest the bequest should have earned, but more important, established the Permanent Committee for the Oliver Wendell Holmes Devise to be composed of 5 members. The Librarian of Congress would be the ex officio chair, and the 4 other members would be appointed by the president to 8-year terms according to a procedure established by law. In the ensuing 70 years, presidents varied greatly in making prompt appointments to the Permanent Committee. But once the first 4 members were chosen, the committee turned its attention to choosing authors for the history of the Supreme Court. The first object specified in the 1955 statute for which the Oliver Wendell Holmes Devise funds could be used. The act mentioned 2 other possible projects, an Oliver Wendell Holmes Devise lecture series and the Memorial Holmes volume included in the 1940 Act, but neither of these got much attention from the various committees. Instead, the initial committee occupied itself fulfilling the statute's directive, quote, to employ 1 or more scholars of distinction with any appropriate assistance to prepare a history of the Supreme Court. Before it could choose authors, the committee had to decide what it wanted the history to look like, and it concluded that the history would be divided by the terms of the Chief Justices. The committee then appointed as general editor Paul Freund, a constitutional scholar and professor at Harvard Law School who was close to Justice Frankfurt. Freund also was chosen as one of the 8 authors selected to write 11 volumes, taking the history of the court up to 1941. According to Stan Katz, the second editor of the devised history, Freund wanted a new kind of history, not just an exploration of law cases, but in Freund's words, quote, history in the broad sense, dealing with the impact of the world upon the Supreme Court and the impact of the court upon the world. Gerald Gunther, another of the authors chosen, but one who eventually gave up his volume, reported that Freund wanted the authors to take, quote, a trifocal approach, not only providing a factual account of the legal history of the court, but also discussing the social and economic forces affecting the court and the consequences of the court's work on the country. Unfortunately, the committee mostly chose the wrong people to achieve Freund's goal. All but one were law professors, and the resulting volumes, long in arriving, represent typical examples of constitutional history in the middle of the 20th century. When volumes changed hands, as happened with the second part of the Chief Justiceship of John Marshall, the results were often better. Ted White produced a book that made his historical training obvious and will stand the test of time. Stan Katz, undoubtedly aware that the Oliver Wendell Holmes devised series needed to go in a different direction, contracted with authors like William Weissach, who had both a law degree and a PhD in history, and who had written a number of books before tackling the devised volume. In record time, I might add. And in a strange coincidence, the 2 books most recently published, Mark Tushnet's On the Hughes Court and Robert Post's on Taft, are written by authors who are third in line to take on their volumes, who both had some historical training and several books under their belts. I think I can say we are not sorry to have waited so long for these 2 different and splendid books. Which brings me to the subject of this afternoon's panels, the Taft Court, Making Law for a Divided Nation, 1921 to 1930. You'll hear from a variety of scholars steeped in the many subject areas covered by Professor Post, and all will have differing views. But I want to end on a personal note. Though I am not an expert in this period of American history or constitutional law, the 1790s are my forte. I believe that Robert Post's volume, which I have read many times in draft, will be considered a great contribution to constitutional history scholarship, even if you read just the footnotes. And it made the pandemic fly by for me. So, thank you.
Oh yeah, I'm supposed to introduce people. It's a moderator's duty to introduce people who need no introduction. So, left to right, we all know Laura Coleman for her great work on legal liberalism, legal realism, the 1960s, 1970s to 80s. What can I say? Mark Tushnet is equally famous for books on comparative constitutional law, constitutional history, constitutional doctrine. And Dan Ernst is my favorite, or at least one of my top 3 favorite historians of the administrative state. Advertisement for
Good head.
Tocqueville's Nightmare is one of the really, truly great books of trying to understand the history of how we got to the modern administrative state. So my job, I think, is simply to tap my watch discreetly. So just every once in a while, give me the side eye, and if I'm going like this, it means you should just keep talking, because who am I? And, oh, yes, go left to right,
Okay.
both ideologically and physically.
Well, no. Well, I'd like to thank Noah. I'd like to thank Madison. I'd like to thank the organizing team that made this wonderful conference possible. I'd like to thank the deans who funded it. And I'd like to recognize Ryan Reff from the Library of Congress, who's sitting in the audience, and from who oversees brilliantly with his wonderful staff the collection of Supreme Court papers from which all historians of the Holmes Devise must draw. I'm supposed to be writing the Holmes Devise of a volume on the Warren Court, and as one who's doing that, I'd also like to thank publicly Mark Tushnet and Robert Post for being such easy acts to follow. In the Justices' Conference Room, Jennifer Lowe of the Supreme Court Historical Society has told me, 4 portraits currently hang. John Marshall over the mantle, Benjamin Cardozo, John Marshall Harlan, and Robert Jackson. With the exception of Marshall, they change periodically, not frequently. After reading Robert's magisterial account of Taft's Chief Justiceship, I wanted to nominate Taft's portrait to hang there permanently with Marshall's. Robert reveals the tact and delicacy of this effective and aggressive political actor who managed the court with fluency and ease. Taft transformed the role of Chief Justice with genial persuasion. He possessed the preternatural capacity to charm even his worst enemies. He packed the court with sympathetic justices he and Harding picked. He dispatched bills he disliked by lobbying, mobilizing the bar, and circulating ethically suspect, in Robert's words, advisory opinions. He shrewdly navigated congressional halls to win legislation that created the Conference of Senior Circuit Judges, and vitally, legislation that cut the court's mandatory jurisdiction. The legislation also provided funds for a new Supreme Court building designed by Taft's chosen architect, and Taft arranged for the selection of the great Charles Evans Hughes as his successor. Wow. Taft was an unparalleled Chief Justice, as Robert so well demonstrates. Now, as I read, I often asked myself why Taft didn't better employ his skills as Chief Justice as Chief Executive. President Taft faced obstacles, to be sure. His own lack of desire for the job, the fractured nature of the Republican Party, and its hatred of using patronage as a club. Robert maintains that Taft lacked the charisma and raw political talent to be an effective president. But I'm not sure that charisma had yet become necessary for presidential success, even though Taft's predecessor, Theodore Roosevelt, possessed loads of it. And Taft's Chief Justiceship proves he had plenty of raw political talent. Still, the scholarly consensus is that Taft was a lackluster president. Did Taft deliver a meh performance in one position and a spectacular one in the other because he considered the court, next to my wife and children, the nearest thing to my heart in life? Did the experience of being president make Taft a better Chief Justice, as Holmes believed? Did Taft have more latitude in the judiciary because although the court irritated some politicians, progressives in the 20s, most didn't care about the court as much as they would later? Whatever the answer, like Brandeis, I find it hard to understand why a man who is so good as a Chief Justice in his function as presiding officer could have been so bad a president. Guido Calabresi recently suggested to me that though Taft was a great court manager and proceduralist, his opinions left much to be desired on the merits, which may help explain his failures as president. So first question to Robert is how he would respond to that. Now, Robert's illumination of how the institution of the Supreme Court worked then and his reflections on how differently it functions now are among these volumes' highlights. The Taft Court may look almost modern in routines, but it was a world apart from today's court. The shift from mandatory to discretionary jurisdiction transformed, Robert says, the court from a tribunal of last resort into the manager of a system of federal law, responsible for supervising the development of national law. As Taft said, that meant the court now had to address its opinions to the public at large, as distinguished from the particular litigants before it. But as Robert also brilliantly shows, the Taft Court didn't. While it seized on the chance to cut its production of full opinions, the ones it issued were, in Robert's words, clearly otherwise virtually indistinguishable from those of the White Court. The Taft Court, he says, went right on speaking with the authority of a single final appellate tribunal whose judgments were primarily addressed to litigants. Opinions were usually short and usually unanimous. And the justices' loyalty to institutional solidarity and the norm of acquiescence remained rock solid. Despite fractious disagreements at conference over votes, nearly 75% of the court's decisions were unanimous during the 1929 term, Robert shows, compared to 29% during the 2022 term. And even though new jurisprudential currents were shaking law schools and professors' authority was beginning to challenge that of the bar and the justices, the court continued to behave as if law was found and declared rather than made and shaped. That's why Taft could dismiss law review articles attacking the court's decisions as just the pesky way academicians get even with us. It wasn't until later that the norm of acquiescence morphed into a contemporary ethic of individual expression, Robert shows, a shift accompanied by our contemporary full-scale crisis about how to distinguish law from politics. There were still cases like Brown v. Board, where the court found unanimity essential to create the sense that, in Robert's words, it was announcing the kind of impersonal law that ought to command respect and obedience. But those decisions were rarities. As Robert brilliantly drives home, the 1920s may have been the last moment in the court's history when the court could automatically imagine itself as speaking with the authority of a simple final appellate tribunal whose judgments were primarily addressed to litigants. Which leads me back to, in conclusion, Taft the Justice's politician. And for Robert, my second question. In Jason Heller's Taft 2012, Taft comes back to the present as a modern day Rip Van Winkle, who time travels. This novel appeared in 2012. He time travels to 2012, and he briefly becomes a wildly popular presidential candidate. The book ends with Taft's president granddaughter swearing him in as a Supreme Court justice in 2021. How would Taft react to the contemporary court as an institution? I wish Robert would tell us. I wonder especially what Taft would make of the fact that all justices, except for Justice Kagan, have prior judicial experience. Taft had that too, of course, but he had lots of other experiences as well. And as Robert shows him writing Justice Sutherland, he believed that there was something about the court that required a justice to have those kinds of experience. Now, I've always been uncertain that it's possible to enlist history in support of normative judgments. But if it is, doesn't Taft's brilliant tenure as Chief Justice suggest what was lost when presidents stopped reaching out to politicians to lead the court? Thank you.
I want to echo the thanks that people have already given to the organizers of this conference. With limited time, I'll forego all the praise that Robert's book deserves. Just one comment about Laura's last line. Can you imagine the reaction today if President Biden nominated Barack Obama to the Supreme Court? I mean, it would, the world would explode. I mean, in light of Robert's book, I actually would, and this conference, I would reframe my Hughes Court book some. I did have a couple of the predecessor articles available to me as I was writing, and the one thing that they led me to do was to deliberately reject the kind of statistical analysis that Robert did in his book. I could come up with jurisprudential explanations for it, but honestly, the answer is it would have been too much a pain in the neck to try to do it. So all praise to him for having done the work. But the story I told in the Hughes Court book is my story, and I guess I'll stick with it now. I'm going to start with some comments on doing an intellectual history of the Supreme Court and follow with some comments on seeing the 1920s from the perspective of the 30s, offering at the end, this was part of my charge, only a sentence or two about federalism if time allows. So throughout the book, the phrase visions of moral agency occurs. Visions of moral agency embedded in the justice's opinion recurs. And I want to be somewhat deflationary about the idea that we should read Supreme Court opinions to discern the visions of moral agency or associated things. I think we have to be careful about giving too much coherent content to any such putative visions. The authors we're dealing with weren't serious intellectuals, after all. Only Holmes qualifies. They were rather more or less ordinary lawyers. Think Babbitt rather than, this is not exactly right, Arrowsmith. But, you know, because Arrowsmith wasn't really a major scientist, but these were Babbitts. Like all of us, these more or less ordinary lawyers did live their lives with ideas about moral agency rattling around in their heads. But those ideas were more like what I call in my book attitudes rather than theories. I toyed with the term sensibility from Jane Austen and ended up using attitudes from Alice in Wonderland, which I think captures the idea better. Maybe we could call these folk theories of moral agency or morality. And importantly, I think there's no reason in general to think that these attitudes or sensibilities or folk theories are internally consistent. If you like, think Walt Whitman, do I contradict myself? So I contradict myself. It's not surprising, I think, to discover in Robert's terms that there are anomalies and inconsistencies in those visions. Or his term is more messy uncertainty. That's to be expected entirely apart from problems of aggregation, deference to opinions authors' particular way of putting things, and the like. It's just they weren't systematic thinkers about moral agency. They were ordinary lawyers. Here I actually want to say a word about Willis Vandemanter as jurisprudent, because I actually think he did have a jurisprudence. To oversimplify, my explanation for his inability to get opinions written was his understanding that law was a seamless web. That's a pretty good understanding. Write one sentence and you discover that they're connected to it a host of other issues that if you're intellectually honest, you have to say something about. And that's indeed a prescription for what one of his colleagues, I think it may have been Hughes, called pen paralysis. What happens, though, if you don't follow things through? Well, as Vandemanter said more politely about some of Holmes's more cryptic opinions, what the heck does that mean? He was right about that. Put another way, if law is indeed a seamless web, any opinion published in real time will contain inconsistencies and anomalies. And within a folk theory of moral agency, there are likely to be competing strands of thought. Only fanatics fail to understand that there are times when their generally preferred vision of moral agency has to yield to alternative visions. When I confront anomalies and inconsistencies in my capacity as an intellectual historian, rather than in my capacity as someone interested in moral agency as such, my attitude is, so to speak, what else should I expect from these particular people? Now, this point about competing strands leads me to my observations about the Taft Court seen by someone who worked on the Hughes Court. I'm now grossly oversimplifying it. In the early 20th century, there were two major accounts of good governance available. One was the progressive account in which legislators and experts sought to or should govern in the public interest. The other was what started out as a critical account of governance through special interest or class legislation, and then turned into a more positive account of a pluralist political system. Just as a note here, for that to happen, the pluralists had to come up with an account that protected individual rights, which didn't happen until the 1930s, and had to was tricky because liberal progressives basically didn't care about individual rights anyway, as shown in Dewey's contortions over free expression during World War I. Now, special interest the special interest approach is entered the historiography coded as conservative with Jones and Howard Gilman, but progressives were against special interest legislation as well. So conservative decisions invalidating legislation as class or special legislation weren't for that reason anti-progressive. Robert starts his section on social and economic legislation by quoting a scholar to the effect that World War I ended progressivism. The predecessor workshop indicates that now seems to be either, we currently think that that's a mistake. Whatever is true of progressivism as a political movement, though, it's pretty clearly, in my view, not true of the Supreme Court. Even in the 1920s, the court had bought into the progressive account of good governance. They accepted the progressive diagnosis that industrialization and urbanization required forms of government intervention that classical liberals would have found unacceptable. As I indicated earlier today, they're not all in Teddy Roosevelt progressives, which is why the most ardent progressives fulminated against the court as reactionary, but they were recognizably part of a modern family of accounts of what good governance required. And I think we can understand this by deploying an idea related to Skowronek's distinction between calendar time and political time. The idea is that the Supreme Court operates on yet another time scale, which I call judicial time. Judicial time is determined by the pace of appointments to the court, which is irregular, and by the often difficult to detect influence of contemporary events on the thinking of justices appointed years or sometimes decades earlier. Judicial time meant, for example, that the Taft Court had on it Holmes and Brandeis, as well as Van Devanter. And as to the latter and the indirect influence of contemporary events, I think of his wife's struggle to learn how to drive. One of the nice things about Van Devanter's letters is they are all, with one exception, all about his family. He doesn't say anything about the Supreme Court work. So you get a pretty good sense of who Van Devanter is as a person, in contrast to looking at the Hughes letters, where you have to struggle to find him to say anything about his family. So you see, there are these weird opinions in which the court refers to the automobile as this new thing that we have to figure out how to deal with. And you can see that in Van Devanter writing about his wife learning to drive. So the progressive and, return to my main theme, the progressive and special interest accounts bubbled along, I have this image of sine waves, with highs and lows. The progressive vision tended to predominate, but sometimes for advantageous reasons, a low point in the progressive account would coincide with a high point in the special interest or pluralist account. So again, we'll find inconsistencies and anomalies. Now that formulation conceals a lot. It hides the characterization problem. How do you know when something is class or special interest legislation rather than legislation for the public interest? Here's how I'd understand the overall picture. Everyone on the task court understood that some special interest legislation simply went too far, as Holmes put it on more than one occasion. And sometimes a majority was able to coalesce around a judgment. This one does go too far. But often, though, to echo Warren's 1913 article, the court found that legislation did indeed serve the public interest. So all the action was in the gap between those points, between too far and not too far. And as Robert shows, there were three candidate methods for figuring out where on the continuum you were. Common sense, evidence, the Brandeis brief, and deference. And to end by restating my general theme, it's not surprising that in an institution organized the way the Supreme Court is organized, we'll find all three methods being used more or less unsystematically. Thank you.
I can't suggest a better way to organize a history of the U.S. Supreme Court than by its Chief Justices. But it must be said that periodizing the history of any institution by its leader's tenure presents some challenges for an author. One is that a new leader works within inherent constraints and also initiates changes completed only after the leader leaves. That is, sometimes the leader's tenure only partially coincides with some important development in the life in the institution, in which case the author has to decide how, if at all, to discuss what happened before or after the leader's time in office. Called this the coincidence problem. Every time I pick up a Holmes devised volume for the first time, and after recovering from the effort that picking up a Holmes devised volume has always entailed and is likely always to entail, I look to see how its author handles this problem. Today I'll discuss how Robert handled it for two topics. The first is the Taft Court's review of social and economic legislation under the due process clauses of the 14th and 5th Amendment. On this topic, Part 5 of the Taft Court has a narrative arc that occurs mostly between July 11, 1921, when Taft became Chief Justice, and February 3, 1930, when he officially retired. The second topic is related, the court's review of administrative agencies. Here, a change began during the Taft Court, but was not completed until long after Taft left, Taft's Chief Justice. If the Taft Court is now remembered, Robert writes, it is for vigorously revising constitutional protections for freedom of contract in ways that would lead directly to the great constitutional crises of the New Deal. Part 5 is about what progressive historians have seen as a temporary departure from the long-term trend of increasingly deferential review of economic and social legislation under the substantive due process doctrine. More than other historians of the Supreme Court, Robert attributes the Taft Court's substantive due process cases to the sudden creation of, in World War I, of a huge national bureaucracy, empowered to control virtually every intimate detail of life. Not only did the federal government nationalize the railroads and other industries, enterprises previously understood to be businesses affected with a public interest, it also fixed the prices of businesses that produced or marketed what Justice George Sutherland called the ordinary commodities of life. Taft, and according to Robert the Nation, regarded the wartime experience ambivalently. Both were caught between the need for efficient government and revulsion at the rapidly expanding prerogatives of the administrative state. Quoting, the pressing question that infiltrated virtually all aspects of American public life during the subsequent decade was whether the profound alterations wrought by the war should be embraced or repudiated. The Taft Court's decisions did not amount to a solid wall of reaction. They sometimes, quoting, affirmed regulation in ways that would have been all but inconceivable before the war. For example, the court unanimously upheld the Transportation Act of 1920, which subjected the nation's railroads to the fostering guardianship and control of the Interstate Commerce Commission, everything from rate regulation to the issuance of securities. But whether the Taft Court struck down legislation or upheld it, it employed legal concepts in what Robert calls a flat, mechanical, arbitrary, and deliberately non-purposive way. Mostly in Part 5, he focuses on decisions determining the constitutionality of legislation, minimum wage laws for women, mandating weights for bread and the stuffing in mattresses, requiring the compulsory arbitration of labor disputes, and so on. The part's last chapter takes up the court's review of how commissions fixed the rates that public utilities could charge its customers. Whether Associate Justice Pierce Butler would succeed in committing the Taft Court to reproduction costs as the one true way of valuing a rate base is the major plot line of the chapter. Butler seemingly succeeds in a 1926 decision, and on the day that Taft withdrew from the court's deliberations because of failing mental and physical health, Butler joined an opinion by Justice Sutherland holding that a return of less than 7.44% on a street railways investment would be confiscatory. Progressives in the Senate vehemently objected to that opinion, and they voted against Charles Evans Hughes' confirmation to succeed Taft because Hughes had represented public utilities before the court. This story of the emergence of an erratic, jumbled jurisprudence more or less coincided with Taft's Chief Justiceship. Harding chose Taft as, in Stanley Cutler's phrase, the judicial representative of normalcy, and Taft delivered by, quote, stringently tightening constitutional restrictions of price controls. But Taft was more concerned with getting his desired holdings than with defending them, normatively or functionally. After dissenting in Adkins, the 1923 case, striking down the District of Columbia's minimum wage law for women, he was content to stay within the gravitational pull of Sutherland and Butler, especially because he, like them, believed that in protecting private property and free contract, the Constitution created the economic incentives necessary for the material progress of the human race. Because the American economy grew steadily almost until the end of his Chief Justiceship, Taft had no occasion to rethink his premises. And when the stock market crash arrived, he was already in cognitive decline and just months from his official retirement. His legacy was a body of precedents that, as the Depression worsened, left the court vulnerable to the charge that its decisions were merely arbitrary restraints on a desirable political reform. A nice narrative arc. A second development, a new jurisprudence of judicial review of administrative agencies, only started during Taft's tenure. Before 1925, Robert writes, the justices thought of themselves as a final appellate tribunal, whose principal job was remedying of a particular litigant's wrong. It was obligated to decide many mundane cases with opinions written principally to justify the results to the litigants. In diversity cases, the justices propounded a general common law, which, like other judges of general jurisdiction, they understood to be public sentiment crystallized in custom, to represent the settled conviction of the people as to what the rule of right conduct should be. This rule of right conduct also defined what liberty was for constitutional purposes. And the court defended that definition against the trespasses of legislators and administrators. Now, I associate what Robert calls the traditional conception of the court as a final tribunal with the very influential definition of the rule of law propounded by the Oxford law don Albert van Dicey in 1885, namely the principle that no one is punishable or can be lawfully made to suffer in body or goods except for a distinct breach of law established in the ordinary legal manner in the ordinary courts of the land. Ordinary courts, that is to say, courts of general jurisdiction, had such an extraordinary role because they decided the private rights of individuals, which in turn defined liberty under the Constitution. As Dicey wrote, the Constitution is the result of the ordinary law of the land. Robert shows that of the Taft Court justices, James McReynolds most consistently and dogmatically insisted that the Constitution was grounded in shared social customs and traditions as recognized in the common law decisions of final appellate tribunals. But McReynolds had plenty of company. Consider the address George Wickersham, formerly Taft's Attorney General, gave upon receiving the American Bar Association's highest honor in 1934. With the nation awash in codes of fair competition promulgated by President Franklin Roosevelt, Wickersham distinguished use from lex, jurisprudence from laws. The jurisprudence of a nation is not made by acts of legislature or decrees of administrative bodies, Wickersham declared. It reflects the morals, the conceptions, and the ideals of the people, grows up from roots that extend back far and flowers out in a people's conception of justice. It forms the woof and fabric of their ideas. Laws come and go, but the jurisprudence of a people moves on from precedent to precedent. In Roberts' telling, the judge's bill, which greatly enhanced the Supreme Court's control over its docket, upset this understanding by making the court the master of its own destiny rather than the servant of litigants clamoring to have a final appellate tribunal sustain their conception of justice. But because the grip on the justices of jurisprudential attitudes and practices associated with the court's traditional role was so strong, a new self-understanding was sometime in coming. Robert thinks that when Taft resigned, neither he nor his brethren fully grasped the court's new role, that of proactive manager of the system of federal law. Common law lawyers who expected courts to wield the authority of finality were bound to have, as Robert writes, a potent skepticism to the emerging administrative state. From the very beginning, the administrative tribunal has faced the hostility of the legal profession. Robert Jackson wrote in 1940, "The lawyer is inclined by habit and training to prefer the court over the administrative tribunal. Lawyers who judge themselves and each other by their skill in conducting trials or arguing before appellate judges assumed that administrators were second-raters who owed their jobs to local political machines. After all, if they were any good, they'd be lawyers. Commissioners do not have any more ability than jurors," a grizzled veteran of the Salt Lake City bar protested when a friend suggested that commissions might be better at certain kinds of fact-finding than courts. In fact, they do not have as much. They are generally ne'er-do-well politicians who are appointed without regard to their competency or their ability. The early 20th century had no greater proponent of the administrative state than Felix Frankfurter, but even he acknowledged the problem. "The personnel of these commissions is one of the most decisive things about them," Frankfurter wrote in 1916 to a friend from law school, "and the personnel is pretty low." Oh, goodness. Given the weight that Robert gives to the wartime state when discussing the Taft Court's review of social and economic legislation, you might expect it to be as significant in the court's review of administrative agencies. I could give you some examples to back that up. Charles Evans Hughes was repelled by the investigation of the aircraft industry and spoke of little Kaisers ruling by their little divine right. But he was also skeptical about administrators before that experience. I have not investigated how many justices of the Taft Court brought similar experiences to the bench, but you can think of a lot. Taft could not displace the Commissioner of Immigration, who was very venal. You have to assume that Willis Van Deventer, as Assistant Attorney General assigned to the Department of Interior, shuddered over some of the appeals from the General Land Office that he heard. Part of the reason why McReynolds was said to failed utterly to comprehend the nature of practical political affairs when he was Attorney General may have been his frustration of what patronage saddles him with. Perhaps the only thing that Pierce Butler and Felix Frankfurter ever agreed on was that the quality of public utility commissioners was pretty low. I'll just read you Holmes and stop. Holmes said, when asked to defer to administrative agencies, "I always tremble a little as I approach these regions, which seems like those where the old maps bore the inscription Hic sunt leones," he wrote to Frankfurter in 1927. "But the bold adventurer is more likely to find more asses than lions." Okay. Sutherland also articulated the problem. Sutherland also said, bureaucracy is a word which we instinctively accept as connoting an offensive form of government, but we must not allow ourselves to be carried away by mere expletives. He accepted the administrative state. Okay, the court had a basis for doing a judicial review of administration decisions when it thought of itself as a court of a final tribunal, an ordinary court of the land, which was to take the whole case. That is to say, we do decide both the law and the facts de novo. They inherited the Taft Court from the White Court, quite a rescission from that when it came to the Interstate Commerce Commission. They had plenty of levers to pull, but they pulled them as a final appellate court. Just how the Supreme Court should proceed differently once the Judges Bill launched it on a new career, a proactive supervisor of the federal law, was not immediately apparent. If they had paid attention to the law professors, and they didn't, they could have gotten some clues. In The Business of the Supreme Court, Frankfurter and James Landis frankly declared, the Supreme Court has ceased to be a common law court. But we're a little vague about what replaced it. Gerald Henderson's study at the FTC suggests that better and more detailed decision-making and opinions might help, which suggested to Frankfurt at least a job to the court of encouraging more forthcoming decision-making by the commissions. Frankfurter, as Thomas Merrill has shown, the sometimes Professor John Dickinson in a 1927 monograph showed how the court could use the fact-law distinction to defer to agencies when they can resolve questions of fact more competently than courts, but to take cases from the agencies that required the judgment of what Dickinson called a tribunal which has under its jurisdiction the whole field of legal relations. So I think the alternate model was around, but it just was not penetrating. Ultimately, the Supreme Court would come to understand its place in the legal process and to express it in one of its opinions. It will bear repeating, the court said at last, that although the administrative process has had a different development and pursues somewhat different ways from those of courts, they are to be deemed collaborative instrumentalities of justice, and the appropriate independence of each should be respected by the other. Not Professor, but Mr. Justice Frankfurter wrote those words, and he wrote them in 1941, at the end not of Taft's Chief Justiceship, but that of his successor.
Now that was great. We're at 2:37. How long do we go, Noah? 3 o'clock. So that leaves us with 23 minutes for questions. So raise your hand for questions. Because I have a question, but I feel like, really?
I think as moderator, you can ask the first
I
question.
can, certainly I could ask the first question, but I wanted to sacrifice my question for the greater good. Okay, fine, I'm gonna ask my question, which is one of the things I noticed about Robert's book, and in all the Holmes Devise books, is that there's not necessarily a lot of discussion of the partisan environment in which these decisions come down. And yet, Taft is a partisan animal. I mean, when he nominates Pierce Butler, oh, he didn't, right, Harding did. Harding nominated him. He's exquisitely insensitive that Pierce Butler's a Catholic and the Republicans want to loop in Catholics. And of course, Harding suffers with nativist Republicans for that. So I would just like to hear what you have to say about this, whether the partisan environment sustains the court. Because one of the things that fascinates me about a court is how it can say, up yours to the political process for a long time. Though in theory, they could be jurisdiction stripped, or people could get angry and appoint people that, the Taft didn't like. I have my own thoughts, which is that there was this 40-party system in place where Southern Democrats were divided from Northern immigrant communities, and Northeastern, Midwestern Republicans were divided from Western insurgents, and that made it so fragmented it was very hard to overrule the court. But I'm more interested in your ideas. What role does the party atmosphere play in the court's sensibility?
You want to do it?
Well, I think one of the things I really liked was that Robert paid a lot of attention to 1924 and the attack by the progressives on the court then. Wasn't as much as William Ross in A Mute of Fury, but I really got a sense of the partisan environment and how it affected the court.
So, not my period, but it is a question I had, was the extent to which Taft was feeling resentment about progressive Republicans, and it lingered in, long after 1912. And you know, certain people like Frankfurter, Donald Richburg, are progressive Republicans. So some of the more sophisticated legal critics of the court are in the same camp. Now, I do think Robert basically does focus on 24 and how the agitation to get, you know, cutting back on the court's judicial review powers goes away rather quickly. But I still wonder if those darn Republicans in the Senate is on his mind and makes him open to Sutherland, Butler, willing to go along with them, you know, and referring to playfully the Bolsheviki on the court, whether that is, it weighs on him, that makes him more vulnerable when it comes to review of judicial legislation. They go along. But I'm not reading his mail, so I don't know what Taft actually thinks.
So my reaction is that there are two political contexts that the justices are in some sense aware of. One is call it the contemporaneous political context, what's happening in politics of the day. The other is the political context in which their understanding of the constitutional order was shaped. And that's decades earlier. So then there's this interplay between the two of them, between those two political contexts, which I think will, you know, there's probably nothing that can be said in general about it. It'll depend on, you know, the strength of the shaping of the consciousness decades earlier and the nature of the political contention, the contemporary political dimension. Just my anecdote about this from, roughly speaking, this period is that Willis Van Devanter thought that he had political influence in the political system based well after it had completely passed. He thought he could get people jobs because he knew lots of politicians. Problem was he knew them 20 years earlier. He didn't know the ones who are around now. So it's that kind of problem. Now that's not resolving cases, but it's this juncture or this existence of two time frames that is significant, I think.
Okay, questions? Yes.
I have a question kind of about sourcing, right? So in the book, I've these letters to Charles Taft and other family members who had political experience in war. I was talking about Charleston, Maryland, Cincinnati, and other he wrote to his grandson and sons about. And you see him talking about the court in these letters. So I guess my question would be twofold. Like, one, how would we feel today if we found out that one of the sitting justices was having conversations with their brother or sister about sitting cases on the court, as Taft is doing in these letters? And two, does it matter that he's having this correspondence with relatives who have the kind of legislative experience that you're talking about, Laura? So he's having this conversation in a kind of a world of legislators and not law. Does that make sense?
Yeah, so this is just an anecdote. I forget the case. It's a case, I think, involving Howard Hughes. The court's incredibly divided about it, 5-4, something like that. Brennan goes home for Thanksgiving, has had Thanksgiving dinner, and discovers that his son has represented Howard Hughes. Had no idea about it, so he recuses himself. The court divides 4-4. Everybody heaves a sigh of relief because they had no idea what they were doing. So, you know, this kind of conversation, you know, it's an indication that that kind of conversation literally didn't occur. Doesn't, and I'm sure doesn't occur in the modern era. Now, the question I suppose we all have is, yeah, but what about Ginny Thomas? That is, do they talk?
I didn't say her.
I know you don't, right?
So, but I think, were we to discover these similar kinds of conversations, we'd be today more bothered by them. Now, you know, there was this book written by Rehnquist Poker Buddy, talked about all the, you know, people he had played poker with, but who knows what they talked about when they played poker. They may have talked about sports. So, norms have changed.
I can recall how shocked I was listening to Abe Fortas and Lyndon Johnson discuss pending cases on the telephone, on the Johnson tapes. So I think norms have changed more recently than we admit.
Noah?
Thank you for these three just fantastic interventions. And putting them next to each other, Dan's opening to say, look, isn't it interesting to periodize by Chief Justice, and here's a story that lines up and here's one that doesn't, makes me think about a tension between Laura and Mark, between your two accounts, which is, Laura, your account opens by stressing Taft as individual and his own charm and his ability to work things. And then Mark, in some ways, you're offering a kind of rejoinder, saying, don't personalize the court. There's this whole judicial time that's unfolding that involves these different appointments, different levels of political time and considerations. And then to come back to Dan, even the two stories that Dan is looking at, they both involve institutional factors much broader than Taft as an individual. The transformations of the court as driven by reconversion from the war, the judges' bill, the relationship between the rise of the administrative state and an earlier judiciary. So it just makes me sort of curious about how, having spent some time with these two volumes of Robert and thinking about the period, and in Mark and Laura's case, wrestling with writing a Holmes devised volume yourselves, how should we think about the relationship between these different factors? If I want to understand how to make sense of this change, should I care that there's an individual who is chief judge, even if it does turn out that they are quite charming and were a former president? Or to go to the other extreme, should I only be focused on these broader institutional factors and the structural relationships between the branches? How do you see this book navigating that tension, and how should we try to navigate that tension?
I'll take a stab at that. For me, there's a key, I would call it, individual variable that you have to think about, which is how good were they as lawyers? So, Hughes was a really good lawyer. Sutherland was a really good lawyer. Later period, Roberts has this line, I don't know if it's true because it comes from Frankfurter, but Frankfurter quotes Roberts as saying, "Who am I to curse the good God that he didn't make me a Holmes or a Brandeis?" He knew he was not as good a lawyer as they were, and Pierce Butler was just a sort of ordinary middling lawyer from the middle of the country, and that is going to affect things. So again, in my period, I'm blocking on the cases, but the incoherence of, I guess it's McReynolds' dissent in one of the key switch in time cases, compared to the coherence of what turns out to be the Sutherland Vandevanter dissent in the Minnesota mortgage moratorium case. That's just the product of that they were better lawyers than McReynolds was.
For me, it depends. I mean, it's the way the Holmes devise was set up to be organized by Chief Justice. And that, I think, makes the Chief Justice much more important than perhaps he otherwise would have been. And when you compare someone like Taft to Stone and Vinson as Chief Justices, you gotta come away wowed by the guy, no matter what you think of his opinions, in my case.
It's all from this side. Interesting. Yeah.
Thank you. So we had some discussion earlier about the court grappling with changes in technology, the automobile, and corresponding social changes, and also about the changing role of the court from a kind of appellate tribunal to one that is speaking more broadly and articulating law. And I wonder just how we should think about the interaction of those two, especially given the kinds of broad transformations in media technology in the public sphere that were occurring during
during precisely this period and a little bit after. How do the sort of transformations in the public affect how the court conceives of its role as speaking to the public, and I don't know, maybe vice versa?
So I think that's a. Let me do it this way. When I refer to the way the justices are influenced by the things that are happening in the society and culture at the time, I picked that up from Robert and Reva Siegel's work on how is it that these old white guys managed to sign on to the women's rights. Brennan, who was very uncomfortable with women, became and the answer is it's somehow something in the air at the time. The mechanism by which that happens is completely obscure, I think. They have this sense that something's going on, but they don't have much of a handle on it. So I may misquote this because I didn't read the chapter on Olmsted, but so in Olmsted, Brandeis has a dissent in which he drafts a line saying, television's coming and they'll be able to watch us through television on our, I'm sorry? In the draft. And Henry Friendly tells him to take it out because that's not how television works. but it turns out that he was right. So he had some sense that there was something going on with the modern technology of communication, but not able to get much of a handle on it. And we can see this today, and the justices themselves comment on it. They have no clue about how the new social media work. What is TikTok from their point of view? From my point of view, what is TikTok? Okay. So was forcing the sale of TikTok a violation of the First Amendment? Who knows? Who knows how to think about that? So the answer is yes. There's something happening, but they don't know what it is. Mr. Jones, in case you didn't get the illusion.
Taft had found out about the Alan Murphy Brandeis Frankfurt connection with the Zionism and the money commitments. What do you think? Would this have been sui generis or just the way things work behind the scenes?
Didn't Taft take money from the Carnegie Corporation? Some kind of annuity? A pension.
I have another question about parties. I'm just going to throw it out there. And that is that when you responded to my first question, you all talked about how the court was influenced by party ideas now and party's idea then. But I was actually interested in a different question. How was Congress or other politicians, George Norris, et cetera, influenced by the court? Because the court, it's not like, I feel that Thomas Cooley was very important to me, so I'm going to write a Thomas Cooley opinion. Well, that's very well and good, but then you could get Norris LaGuardia. You could get smashed. And what's amazing is that from duplex printing and black and white taxi and a whole bunch of decisions that were not popular and a whole theory of common law that was widely being repudiated, the court did not inspire much controversy. Now, one theory is, everybody just trusted institutions back then. It's sort of like Walter Cronkite said the Vietnam War was okay, so the Vietnam War was okay. Another theory is politicians in the external world just couldn't unite. One of the things I thought was interesting about Robert's account of Pierce versus Society of Sisters is it doesn't discuss who Governor Pierce was. He's this progressive populist backed by the Klan. Now, that makes him a very weird character. And it does mean that when Sutherland, of all people, who hates Catholics, writes an opinion, it gets huge applause from Catholics. Why? Because they hate all federal and state reforms of education, right? They're the same people who fought the federal Department of Education bill in 1921, the child labor law in 1922, the Women's and Children's Bureau. And so in some sense, because the Democratic Party split right down the middle between Klan supporters and Southerners and Northern immigrants who are very suspicious of progressive maternalist reforms, the court was skates through unscathed. There's just not like today. Like,
Well,
there's no
but-
SCOTUS commission.
You have constitutional amendments being suggested in 1924 that would require a majority to overturn or a 2/3 vote by Congress
So
to
the child
redo-
labor law has almost uniform support from every Republican. It passes the Massachusetts House of Representatives, the lower house of the Massachusetts, almost unanimously until the Catholics weigh in. And so why did the Catholics weigh in? In support of, remember, they're all members of they're AFL people,
Right.
right? So why are they all saying, no, but we have to fight to protect child labor? Because the Klan supports that amendment. And so you have this weird interaction where progressives are saying we need a minimum wage law for women in Colorado. And the Colorado Klan says, yeah, we need a minimum wage law. And then people like Frankfurt say, maybe we don't need a minimum wage. Right? I just think it's this fragmented partisan environment. I call it a four-party system, which means the court can skate through unscathed as soon as the ethnics join up, we call them white ethnics, join up with the Southerners and form a new deal. Now things are going to get a little messy because we'll have a two-party system, but there's not a two-party system in the 1920s. It's 103 ballots in 1924 to nominate a president.
Right.
It's a four-party system.
Right.
And so there's no way you can coalesce. I think that explains the success of the Taft Court more than the fact that Taft thought this in the morning or thought that in the morning.
So this is a contrarian view, I think, or certainly contrary to what you're articulating. My default assumption would be that for most politicians, they don't know and they don't care. They'll take their positions on the issues that come up completely independent of what's going on in the Supreme Court.
Even duplex printing?
So the answer is, I don't know about particular cases, but the default will be, they do their thing, the Supreme Court does its thing. Sometimes they come into conflict, and then we'll see what happens when the conflict.
So different from today, right?
Well, I'm not sure.
There's a marvelous illustration in Fortune magazine from 1934, which is the New Deal firmament. And, there's lots of representations with the New Deal, with alphabet soup and all this. But this actually has the celestial firmament with different institutions of different sizes. And it's great because AAA completely blocks out the university, the Department of Agriculture, things like that. The court is in a tiny corner, and they're wearing like wizard's robes with a telescope. And I don't know, that's a kind of an exaggeration, but it does suggest that it could be more marginal. And I think what I would investigate was what the party strategies are at the time. Find the exceptional cases where you're sitting within the party leaders or the congressional figures when they do talk about it. And I think it's probably rare, and then you'd want to see what would be those occasions and make a generalize from that.
With that, it's literally turned 3 o'clock right now. What a wonderful panel. Thank you so much, guys.